A non-profit organization is an organization the purpose of which is something other than making a profit. A non-profit organization is often dedicated to furthering a particular social cause or advocating for a particular point of view. In economic terms, a non-profit organization uses its surplus revenues to further achieve its purpose or mission, rather than distributing its surplus income to the organization's shareholders as profit to dividends. This is known as the distribution constraint. The decision to adopt a non-profit legal structure is one that will often have taxation implications, particularly where the non-profit seeks income tax exemption, charitable status and so on. The terms non-profit and not-for-profit are not consistently differentiated across jurisdictions. In layman's terms, they are usually equivalent in concept, although in various jurisdictions there are accounting and legal differences. The non-profit landscape is highly varied, although many people have come to associate NPOs with charitable organizations. Although charities do make up and often high-profile a visible aspect of the sector, there are many other types of non-profit organization. Overall, they tend to be either member-serving or community-serving. Member-serving organizations include mutual societies, cooperatives, trade unions, credit unions, industry associations, sports clubs, retired servicemen's clubs and peak bodies, organizations that benefit a particular group of people, i.e., the members of the organization. Typically, community-serving organizations are focused on providing services to the community in general, either globally or locally. Organizations delivering human services programs or projects, aid and development programs, medical research, education and health services, and so on. It could be argued many non-profits sit across both camps, at least in terms of the impact they make. For example, the grassroots support group that provides a lifeline to those with a particular condition or disease could be deemed to be serving its members and the broader community. Many NPOs use the model of a double bottom line in that furthering the cause is more important than making a profit, though both are needed to ensure the organization's sustainability. Although NPOs are permitted to generate surplus revenues, they must be retained by the organization for its self-preservation, expansion, or plans. NPOs have controlling members or a board of directors. Many have paid staff including management, whereas others employ unpaid volunteers and executives who work with or without compensation. In some countries, where there is a token fee, in general it is used to meet legal requirements for establishing a contract between the executive and the organization. Designation as a non-profit does not mean that the organization does not intend to make a profit, but rather that the organization has no owners and that the funds realized in the operation of the organization will not be used to benefit any owners. The extent to which an NPO can generate surplus revenues may be constrained, or use of surplus revenues may be restricted. Objectives and goals. Some NPOs may also be a charity or service organization. They may be organized as a profit corporation or as a trust, a cooperative, or they exist informally. A very similar type of organization termed supporting organization operates like a foundation, but they are more complicated to administer, hold more favorable tax status and are restricted in the public charities they support. The goal is not to be successful in terms of wealth, but in terms of giving value to the groups of people they administer to. Functions. NPOs have a wide diversity of structures and purposes. For legal classification, there are, nevertheless, some elements of importance. Management provisions, accountability and auditing provisions, provisory for the amendment of the statutes or articles of incorporation, provisions for the dissolution of the entity, tax statuses of corporate and private donors, Tax status of the founders. Some of the above must be expressed in the organization's charter of establishment or constitution. Others may be provided by the supervising authority at each particular jurisdiction. While affiliations will not affect a legal status, they may be taken into consideration by legal proceedings as an indication of purpose. Most countries have laws that regulate the establishment and management of NPOs and that require compliance with corporate governance regimes. Most larger organizations are required to publish the financial reports detailing their income and expenditure publicly. In many aspects they are similar to corporate business entities, though there are often significant differences. Both not-for-profit and for-profit corporate entities must have board members, steering committee members, or trustees who owe the organization a fiduciary duty of loyalty and trust. A notable exception to this involves churches, which are often not required to disclose finances to anyone, including church members. Formation and structure. In the United States, non-profit organizations are formed by filing bylaws or articles of incorporation or both in the state in which they expect to operate. The act of incorporation creates a legal entity enabling the organization to be treated as a distinct body by law and to enter into business dealings, form contracts, and own property as individuals or for-profit corporations can. Non-profits can have members, but many do not. The non-profit may also be a trust or association of members. The organization may be controlled by its members who elect the board of directors, board of governors, or board of trustees. A non-profit may have a delegate structure to allow for the representation of groups or corporations as members. Alternatively, it may be a non-membership organization and the board of directors may elect its own successors. The two major types of non-profit organization are membership and board only. A membership organization elects the board and has regular meetings and the power to amend the bylaws. A board-only organization typically has a self-selected board and a membership whose powers are limited to those delegated to it by the board. A board-only organization's bylaws may even state that the organization does not have any membership, although the organization's literature may refer to its donors or service recipients as members. Examples of such organizations are Fair Vote and the National Organization for the Reform of Marijuana Laws. The Model Non-Profit Corporation Act imposes many complexities and requirements on membership decision-making. Accordingly, many organizations, such as Wikimedia, have formed board-only structures. The National Association of Parliamentarians has generated concerns about the implications of this trend for the future of openness, accountability, and understanding of public concerns in non-profit organizations. Specifically, they note that non-profit organizations, unlike business corporations, are not subject to market discipline for products and shareholder discipline of the capital. Therefore, without membership control of major decisions such as election of the board, there are few inherent safeguards against abuse. A rebuttal to this might be that as non-profit organizations grow and seek larger donations, the degree of scrutiny increases, including expectations of audited financial statements. A further rebuttal might be that NPOs are constrained by their choice of legal structure from financial benefit as far as distribution of profit to members and directors is concerned. Tax exemption. In many countries, non-profits may apply for tax-exempt status, so that the organization itself may be exempt from income tax and other taxes. In the United States, to be exempt from federal income taxes, the organization must meet the requirements set forth by the Internal Revenue Service. Australia. In Australia, non-profit organizations include trade unions, charitable charitable entities, cooperatives, universities and hospitals, mutual societies, grassroots and support groups, political parties, religious groups, incorporated associations, not-for-profit companies, trusts and more. Furthermore, they operate across a multitude of domains and industries, from health, employment, disability and other human services to local sporting clubs, credit unions and research institutes. A non-profit organization in Australia can choose from a number of legal forms depending on the needs and activities of the organization. Cooperative, company limited by guarantee, unincorporated association, incorporated association or incorporated association, a council. From an academic perspective, social enterprises for the most part considered a subset of the non-profit sector, as typically they too are concerned with a purpose relating to a public good. However, these are not bound to adhere to a non-profit legal structure, and many incorporate and operate as for-profit entities. In Australia, non-profit organisations are primarily established in one of three ways: companies limited by guarantee, trusts and incorporated associations. However, the incorporated association form is typically used by organisations intending to operate only within one Australian state jurisdiction. Non-profit organisations seeking to establish a presence across Australia typically consider incorporating as a company or as a trust. Belgium. By Belgian law, there are several kinds of non-profit organisation: Vereniging zonder winstgemaak, Vereinigung ohne Gewinnerzielungsabsicht, or association sans but lucrative. International Vereniging zonder winstgemaak or association international sans but lucrative for international non-profit organisations. Stichting van Openbaarnute Foundation d'Utilité Publique. These three kinds of non-profit organisation are in contrast to a fourth, vrijwillige vereniging or association de fait, an informal organisation, often started for a short-term project, or managed alongside another NPO that does not have any status in law, so cannot purchase property, etc. Canada allows non-profit organizations to be incorporated or unincorporated. They may incorporate either federally under Part 2 of the Canada Business Corporations Act, or under provincial legislation. Many of the governing acts for Canadian non-profits date to the early 1900s, meaning that non-profit legislation has not kept pace with legislation that governs for-profit corporations, particularly with regards to corporate governance. Federal, and in some provinces, incorporation is by way of letters patent, and any change to the letters patent requires formal approval by the appropriate government, as to bylaw changes. Other provinces permit incorporation as of right by the filing of articles of incorporation or articles of association. During 2009, the federal government enacted new legislation repealing the Canada Corporations Act, Part 2 of the Canada Not-for-Profit Corporations Act. This act was last amended on the 10th of October 2011, and the act was current until the 4th of March 2013. It allows for incorporation as of right, by articles of incorporation, does away with the ultra vires doctrine for non-profits, establishes them as legal persons, and substantially updates the governance provisions for non-profits. Ontario also overhauled its legislation, adopting the Ontario Not-for-Profit Corporations Act during 2010, pending the outcome of an anticipated election during October 2011. The new act is expected to be in effect as of the 1st of July 2013. Canada also permits a variety of charities. Charitable status is granted by the Canada Revenue Agency upon application by a non-profit. Charities are allowed to issue income tax receipts too. Donors must spend a certain percentage of their assets and file annual reports in order to maintain the charitable status. In determining whether an organization can become a charity, CRA applies a common law test to its stated objects and activities. These must be the relief of poverty, the advancement of education, the advancement of religion, or certain other purposes that benefit the community in a way the courts have said is charitable. Charities are not permitted to engage in partisan political activity. Doing so may result in the revocation of charitable status. However, a charity can carry out a small number of political activities that are non-partisan, help further the charity's purposes, and subordinate to the charity's charitable purposes. In France, non-profits are called associations. They are based on a law enacted the 1st of July 1901. As a consequence, the non-profits are also called Association LOI 1901. A non-profit can be created by two people to accomplish a common goal. The association can have industrial or commercial activities of both, but the members cannot make any profit from the activities. Thereby, workers' unions and political parties can be organized from this law. In 2008, the National Institute of Statistics and Economic Studies counted more than 1 million of these associations in the country, and about 16 million people older than 16 are members of a non-profit in France. The non-profits employ 1.6 million people, and 8 million volunteers for them. This law is also relevant in many former French colonies, particularly in Africa. Hong Kong. The Hong Kong Company Registry provides a memorandum of procedure for applying to Registrar of Companies for a license under Section 21 of the Companies Ordinance for a limited company for the purpose of promoting commerce, art, science, religion, charity, or any other useful object. In India, non-governmental organizations are the most common type of societal institutions that do not have commercial interests. However, they are not the only category of non-commercial organizations that can gain official recognition. For example, memorial trusts, which honor renowned individuals through social work, may not be considered as NGOs. They can be registered in 4 ways: trust, society, Section 25 company, special licensing, schools, sports. Registration can be with either the Registrar of Companies or the Registrar of Societies. The following laws are constitutional articles of the Republic of India are relevant to the NGOs. Articles 19 and 30 of the Constitution of India. Income Tax Act 1961. Public Trusts Acts of various states. Societies Registration Act 1860. Section 25 of the Indian Companies Act 1956. Foreign Contribution Act 1976. Ireland. The Irish Non-Profits Database was created by Irish non-profits knowledge exchange to act as a repository for regulatory and voluntarily disclosed information about Irish public benefit non-profits. The database lists more than 10,000 non-profit organizations in Ireland. INCEX is currently looking for government funding to continue to provide the service and maintain the accuracy of the database. Japan. In Japan, an NPO is any citizens group that serves the public interest and does not produce a profit for its members. NPOs are given corporate status to assist them in conducting business transactions. As at February 2011, there were 41,600 NPOs in Japan. 200 NPOs were given tax-deductible status by the government, which meant that only contributions to those organizations were tax-deductible for the contributors. Russian law contains many legal forms of non-commercial organization, resulting in a complex, often contradictory, and limiting regulatory framework. The primary requirements of that NCOs, whatever the type, do not have the generation of profit as the main objective and do not distribute any such profit among the participants. Civil Code. Most commonly there are 5 forms of NCO. Public associations. A public association is the form most comparable to an association, as used in international parlance. A public association is a membership-based organization of individuals who associate on the basis of common interests and goals stipulated in the organization's charter. Foundations are property-based, non-membership organizations created by individuals or legal persons to pursue social, charitable, cultural, educational, or other public benefit goals. Institutions. The institution is a form that exists in Russia and several other countries of the former Soviet Union. Like foundations, institutions do not have members. Unlike foundations, however, institutions do not acquire property rights in the property conveyed to them. Moreover, the founders are liable for any obligations of the institution that it cannot meet on its own. Non-commercial partnerships. A non-commercial partnership is a membership organization pursuing activities for the mutual benefit of members. Therefore, assets that have been transferred to an NP as donations can be used for purposes other than those having public benefit. Autonomous non-commercial organizations. An autonomous non-commercial organization is a non-membership organization undertaking services in the field of education, social policy, culture, etc., which in practice often generates income by providing its services for a fee. South Africa. In South Africa, certain types of charity may issue a tax certificate when requested, which donors can use to apply for a tax deduction. Charities, NGOs, may be established as voluntary associations, trusts and non-profit companies. Voluntary associations are established by agreement under the common law, and trusts are registered by the Master of the High Court. Non-profit companies are registered by the Companies and Intellectual Property Commission. All of these may voluntarily register with the Directorate for Non-Profit Organizations and may apply for tax-exempt status to the South African Revenue Service. United Kingdom. In the UK, many non-profit companies are incorporated as a company limited by guarantee. This means that the company does not have shares as shareholders, but it has the benefits of corporate status. This includes limited liability for its members and being able to enter into contracts and purchase property in its own name. The profits of the company must be invested in achieving these goals and not distributed to the company's members. Since the Companies Act 2006, non-profit companies may be formed as a community interest company. These are forms of company limited by guarantee, a company limited by shares but with special conditions, and are intended specifically to ensure that the profits and assets of the company are used for the public good, even when managed for profit. A charity is a non-profit organization that meets stricter criteria regarding its purpose and the method in which it makes decisions and reports its finances. For example, a charity is generally not allowed to pay its trustees. In England and Wales, charities may be registered with the Charity Commission. In Scotland, the Office of the Scottish Charity Regulator serves the same function. Other organisations that are classified as non-profit organisations elsewhere, such as trade unions, are subject to separate regulations and are not regarded as charities in the technical sense. cents. United States. For a United States analysis of this issue, see 501. And charitable organization. After a non-profit organization has been formed at the state level, the organization may seek recognition of tax-exempt status with respect to U.S. federal income tax. That is done typically by applying to the Internal Revenue Service. Although statutory exemptions exist for limited types of non-profit organization, the IRS, after reviewing the application to ensure the organization meets the conditions to be recognized as a tax-exempt organization, may issue an authorization letter to the non-profit granting it tax-exempt status for income tax payment, filing, and deductibility purposes. The exemption does not apply to other federal taxes such as employment taxes. Additionally, a tax-exempt organization must pay federal tax on income that is unrelated to their exempt purpose. Failure to maintain operations in conformity to the laws may result in the loss of tax-exempt status. Individual states and localities offer non-profits exemptions from other taxes such as sales tax or property tax. Federal tax-exempt status does not guarantee exemption from state and local taxes, and vice versa. These exemptions generally have separate applications, and the requirements may differ from the IRS requirements. Furthermore, even a tax-exempt organization may be required to file annual financial reports at the state and federal levels. A tax-exempt organization's 990 forms are required to be available for public scrutiny. An example of a non-profit organization in the U.S. is Project Vote Smart Governance. The board of directors has ultimate control over the organization, but typically an executive director is hired. In some cases, the board is elected by a membership, but commonly, the board of directors is self-perpetuating. In these board-only organizations, board members nominate new members and vote on the fellow directors' nominations. Part 6, Section A, Question 7A of the Form 990 asks members, stockholders, or other persons who had the power to elect or appoint one or more members of the governing body. Accreditation. A non-profit organization in the United States can receive an accreditation by undergoing a third-party review from the Standards for Excellence Institute to ensure efficient use of resources.